Good afternoon. Welcome to Division 7 of the Court of Appeals. We have two cases on the 1:30 docket for this afternoon, and I see that counsel are ready for the first case, which is Ginn Battle versus Battle Mountain. I'm not going to go through all the procedures. I assume counsel have received a written copy of what those procedures are and are familiar with those. I will say a couple of things. I would like anybody in the courtroom who has a cell phone to please turn it off, as it can interfere with our recording equipment for some reason. And then secondly, I want to just remind counsel, if you didn't already know, that there is a toggle switch on the podium here to raise and lower the podium to whatever height's most comfortable for you. To my left is Judge Harris, to my right, Judge Ashby. We're the division for this case. Do you have any questions before we proceed? Okay, we're ready to proceed then, counsel.
Thank you. My name is Theodore W. Brin, registration number 14566. I represent two of the appellants, Battle Mountain Limited Liability Company and Sensible Housing Co., Inc. I am going to split my time, obviously, with Paul Vorndren, who represents Battle Mountain Corporation, and I will save some time for him to speak and possibly for a reply. The first thing I want to explain is why my client continues to fight this matter and refuses to give up in the face of so many years and so much adversity. There are two important facts that have never been acknowledged by the trial court that motivate my client. The first, and this is, the first one is that part of the disputed property, which is the subject of the plaintiff's appellee's deed of trust, was released from the deed of trust many years ago. So my client believes, and I believe, that part of the property should not be subject to the foreclosure action because it was released from the deed of trust many years ago. The second fact that motivates my client to keep fighting is that nobody has ever figured out whether title to any part of this property was transferred to Battle Mountain Corporation, Battle Mountain Limited Liability Company, or Sensible. The trial court in the 1099 order analyzed a stock transaction. I've referenced it in my brief as the Nevis transaction and said that it was not a valid transaction. Therefore, my client did not become the owner of any of the property. There, however, is a deed, two deeds actually, or maybe even three, from Battle Mountain Corporation to Battle Mountain LLC and to Sensible. Those deeds have never been looked at. Those deeds were not signed by Jeff Tucker. Those deeds were signed by the president of the transferring company, and his name was, I'm stumbling, I can't find his name, but it wasn't Jeff Tucker. That person's authority to sign those deeds and transfer the property has never been looked at by the trial court. So there's an independent basis upon which title to the property could have been transferred. Mr. Jeff Tucker would tell you that he had authority as the director, the sole director of the company, which was completely separate and apart from whether or not he owned the stock, to have the president of the company transfer the property to Battle Mountain LLC and Sensible. I just found my note. Those deeds were signed by Jose Perez. The trial court has never looked at that transfer deed or those transfer deeds and whether they were valid or they were invalid. And those are the basis for the claim of ownership in this case. Instead, the trial court has refused to look at these facts. In my opinion, they've short-circuited the process. They've gone back to this 1999 order over and over again and said, that's the beginning and the end of everything we have to decide. And that's just not accurate. The specific points that I raised in my brief, and there are many, I don't have enough time, obviously, to go over all of them, But the first thing I want to speak about is this 20-year rule. We may make an argument that because the underlying debt has been extinguished pursuant to statute, the lender can do nothing with it. It's really a very simple argument. If you file the lawsuit and you're foreclosing on a deed of trust, either with the public trustee or through a judicial foreclosure process like this, or if you have a judgment and you're foreclosing on a judgment lien, if the money gets paid, as an example, if the money gets paid, the debt is extinguished, clearly the lender, cannot proceed to foreclose on property because there is no further debt. The statute in this case, the 20-year rule, and I'm not going to even talk about the California rule, the 20-year bar of CRS section 1352-102-2A says that after 20 years, the judgment is considered as satisfied in full. If it's satisfied in full, it's the same as if it was paid. And clearly, it would be totally unfair to allow a foreclosure if there's no money owed. That's what the statute says. This argument has nothing to do with the statute of limitations. It has nothing to do with when the civil action was filed. There's nothing in the law anywhere, in the statute or in the case law, or that's been cited by the lender here, the plaintiff, that says that either the filing of a lawsuit or anything else, or entry of a judgment, stops the running of this rule that's set forth in 1352-102-2A. Now, the lender, the plaintiff here, could have revived that judgment. There are procedures for reviving both county court and district court judgments. They could have revived it. I don't know off the top of my head how much longer it would have lasted had they revived it, but they could have revived it, and it would have lasted more than 20 years. But under this statute, it's very, very clear that after 20 years, there's no more debt. If there's no more debt, you can't foreclose on security that secures payment of the debt. So in May of 2011, that was 20 years after the judgment was entered in Colorado. The judgment was entered in Colorado in, I want to say, May of 20 years before that, more than 20 years before that. So the judgment cannot be enforced anymore. The order, the final order, as I've defined it in our opening brief, came down in 2017. At the time that the foreclosure order came down, there was no debt, so you could not, a foreclosure order could not be entered. The next thing, or subject area that I'd like to cover is, I guess, the issue of standing. In the final judgment that came down in 2017, which is one of the things that's being appealed here by my clients, the doctrine, the principle of standing was misapplied by the court. What the court said is, we find, based on issue preclusion, that Sensible doesn't have an interest in the property, and therefore a summary judgment enters against Sensible, and therefore they don't have standing. Well, they had standing because they were a defendant, they had a claim. At the time that final judgment was entered by the court, they were a defendant, and they could put forth 1, 2, 3, as many defenses as they thought were appropriate. One of the defenses that they put forward was the 20-year rule.
Well, counsel, I understand that at the beginning of the case, they were a defendant. They also became something of a plaintiff, quiet title claims, counterclaims.
Correct.
Okay. So why didn't standing apply to that? But aside from that, at the beginning of the case, as a defendant, of course, you can raise your defenses. And I think that's what the Supreme Court held. But in the interim, it's been determined that Sensible does not have an interest in the property. How can a party without any interest in the property raise any defense to a foreclosure on the property? We can't grant you relief You're not entitled to it because you have no interest in the property.
This case is gargantuan in terms of the twists and turns of the procedures. The original, I'm sure you all agree with that. The original 1990 order got appealed. It went up, Battle Mountain 1, Battle Mountain 2, Battle Mountain 3. At the end, it went back down, and the Eagle County District Court then entered an order against the interests of Sensible. That case then went up, and Sensible had two interests. One was Pine Martin, one was Piney Lumber. There were two separate entities. Sensible became the holder of those interests. So, and I can get I don't have it right in front of me right now. It's at my desk. But that case went up as well. That case, the Court of Appeals, can't remember which division, said that Pine Martin, I can't remember if it was Pine Martin or Piney Lumber, that one of them had no interest, they had no further claim, but that the other entity owned by Sensible, that Sensible became the successor to, that they did have an interest.
Well,
And
actually,
they sent it,
they didn't say they had an interest. They said there was a question as to whether it had an interest.
yes, okay, fair enough. But it was sent back to the trial court for a determination. So when it got sent back to the trial court, that claim by Sensible for that one parcel, it was still alive. It was still a live claim. And it was a defendant. Then the lender, the plaintiff, renewed motions for summary judgment, filed new motions for summary judgment. And so Sensible did have a live claim at the time that the final judgment was entered. It was still a party. It had not been entirely dismissed out of the case. It had one sliver of an interest. And as a defendant with one sliver of an interest, it had the right to raise the 20-year rule.
But whether it was determined in 1999 or in 2011 or in 2017 that Sensible didn't have an interest, once it is determined that Sensible didn't have an interest, why should we consider anything else? I mean, in 2017, and I understand this is one of your points of error, the court granted this preclusive effect to this judgment in the other case, declaring that these deeds are invalid, that Sensible is relying on. Okay, so at that point, the court determines you have no interest if it hadn't been determined already. So once that's been decided, if that is correct, we're assuming that's correct, but if that's correct, how can Sensible stand in the way of the foreclosure?
Well, two comments, and my time's running out, which I understand. Two comments. First is, I believe that the trial court and the court has a duty to follow the law regardless of whether somebody is standing there saying this is what the law is and you should follow it. I think there's a duty on courts to follow the law. Secondly, who's to say that the court didn't? It's a question of the chicken and the egg. Which came first? Did the trial court in the final judgment first decide that there was no standing and then say, now I don't have to deal with the 20-year rule? They could have done it the other way, and they could have said, well, first we're going to look at this 20-year rule, and then we're going to decide the issue of standing. So they were simultaneous decisions, and right up until the point of that final judgment, Sensible had standing. They had a claim. The trial court ultimately, of course, decided that they couldn't make the claim because they didn't have standing, because they didn't have an ownership interest in the property. But which came first? So, okay.
Thank you.
I think now that
Are
I'm
you gonna
down to
reserve your
3
time?
minutes, I'll kick it over to Paul.
May it please the court, my name is Paul Vornder, and I'm with the law firm Jones & Keller, and I represent Battle Mountain Corporation. And I think from the briefing, it's probably clear to you all that there are two Battle Mountain corporations with that name. I want to address, given the amount of time I have here, the very narrow issue which is most important to my client, and that is the denial of the motion to intervene in the case below. In determining whether a party under Rule 24A has asserted a right and is entitled to intervene, the trial court is simply supposed to determine whether the party has identified a right. And here, what the court did was, instead of accepting that the right has been identified, the court skipped to the final step and determined that there's no legitimate claim to property that was made by BMC without granting intervention. And in our pleadings, we cite a couple of cases. One is O'Hara Group, Denver Limited, and that's followed up by Fagan v. Alexa Group. In those cases stand for the proposition that once a party has identified an interest in the litigation, that the trial court should grant intervention, subject to the other elements under Rule 24A. The court didn't consider any of the other elements under Rule 24A, but instead just denied intervention. There was a bit of briefing confusion, perhaps by one of the appellees and in my brief, in terms of what is the standard of review and what is the basis for the standard of review by this court of the trial court's decision. And hopefully I cleared that up in the reply brief, pointing out that, in fact, the standard of review is de novo by this court of the trial court's decision when the trial court has gotten, as it has here, to the ultimate legal question of whether BMC has identified an interest in property. And it looks like I've got 1 minute left. I'd like to reserve that for Mr. Gray.
Sure. Counsel?
Thank you. May it please the court, Michael Martin, as counsel for the appellee, Ginn Battle Lender. The issues raised in this appeal have all been decided in numerous instances, multiple times previously during the 20 years that this case has been pending. At some point, the parties are entitled to some finality, and this litigation must come to an end. And this point, at least in my client's estimation, has been reached. Battle Mountain LLC and Sensible sought to relitigate, in this case, summary judgments that were entered against them on my client's claim for judicial foreclosure on December 16th of 1999. And
Counsel, let me ask you about Sensible, though, because I think
Sure.
it seems accurate, though, that as to Sensible, there were these two pieces, the Pine Martin, and it was sent back from this court on one of those pieces, and that did not get resolved until the most recent order in which the court in this case applied issue preclusion or claim preclusion to the judgment in the other case.
I think I can clarify that because in the December 16th, 1999 order, summary judgment was entered against the predecessors to Sensible, Pine Martin and Piney Lumber, on the judicial foreclosure claim. The court specifically acknowledged, though, that they claimed an independent chain of title, separate and apart from what they claimed through Battle Mountain Corporation. They claimed an independent chain of title and entered summary judgment on the judicial foreclosure claim, but said, to the extent you claim title independently, that will go forward. That did go forward. We ended up filing a spurious document action in which it was finally determined that Sensible had no interest in the property, either through Piney Lumber or Pine Martin Mining. That was upheld on appeal in this court when the court decided that Mr. Tucker had no authority to act on behalf of either Piney Lumber or Pine Martin Mining, and struck and released the deeds by which they claimed an interest in the property. And so at that point, there was clearly no interest in the property. The deeds, the quitclaim deeds, They had been released, they had been determined to be spurious documents, and in the final judgment, the court reiterated that. But to be clear, the motion for summary judgment in which the release, or the judicial foreclosure claim which they are attempting to attack now, summary judgment was entered against Sensible and Battle Mountain or Battle Mountain LLC in December 16th of 1999. And that judgment was fully affirmed by this court in Mortgage Investments Corporation versus Battle Mountain 93 P3rd 557. And I'm aware of the court's admonition not to quote from cases, but in this instance, there seems to be some type of issue as to exactly what the court's ruling was in that case, whether or not it was affirmed or not on appeal once it came back from the trial court. And at page 558 of that opinion, the court notes that Piney Lumber Company, Pine Martin Mining Company, and Battle Mountain Limited Liability Company, all of the appellants here, appealed the summary judgment order and orders entered in favor of plaintiff Mortgage Investment Corporation. Now, those orders were the orders striking their claims and defenses and dismissing the quiet title counterclaim of Battle Mountain Corporation. Now, and the court specifically says, those orders entered in favor of plaintiff Mortgage Investments Corporation, now known as New Mortgage Investments Corporation, we affirm. The trial court judgment of December 16, 1999 was affirmed in its entirety, and there can be no argument, or at least credible argument to the contrary. And I would maintain that any such argument is really specious. And with respect to that one remaining piece, as noted previously, the summary judgment was granted with respect to the entirety of the Piney Lumber and with respect to the Pine Martin Mining, there was that issue of the 2015 stock certificate, and that was remanded back to the trial court. The spurious document action was then filed with respect to that stock certificate, and the quitclaim deeds from Piney Martin and Piney Lumber that were signed by Mr. Tucker, purportedly on behalf of those entities in conveying those parcels to Sensible. That spurious document action was tried in the Eagle County District Court. The court determined that the stock certificate was a sham and that the quitclaim deeds were spurious documents. Went up to this court. This court affirmed the factual finding that the stock certificate was a sham, but said that it was not recorded for purposes of the spurious document action and thus couldn't be a spurious document, but determined that the quitclaim deeds through which Sensible claimed an interest in the property were spurious documents. Given that ruling, once the matter went back to the trial court as part of, after the determination in this court on the spurious document action, went back to the trial court, we filed a motion then for summary judgment on that sole piece that was remaining with respect to Sensible, and said they can't establish title to the property, which is a prerequisite for a quiet title action, because this court has determined they have no claim to title, that the quitclaim deeds through which they claim title were spurious documents, and the trial court agreed with that. And given the court's ruling in the Battle North versus Sensible, the 370p3rd 238 case, it really had no other course of action to follow.
Counsel, let me ask you about the standing question and the court's application of it in the most recent order. How can that be squared with the Supreme Court's decision in Battle Mountain 2, where it said that, I believe it was sensible, I'm not exactly sure, but maybe all the defendants had standing to raise at that time the statute of limitations defense merely by virtue of being named defendants?
Yeah, the statute of limitations defense to the judgment had already been entered against all these defendants in 1999 and fully affirmed on appeal. The only thing, so they had no standing at that point in time to come back and try to relitigate or re-argue something. I agree that there was a sliver that it remained only to file the motion for partial summary judgment as to Sensible's claim that it had an independent chain of title or claim to a portion of the property. But the standing issue as it relates to the judicial foreclosure claim, which they're trying to defeat, that had already been decided in 1999, in December 16th of 1999.
But wasn't the Supreme Court saying that in, I don't know, 2003 by this time, that they could raise the statute of limitations? They had standing to do that. So 4 years later, when that ruling of 1999 is up on appeal, the Supreme Court says they have standing to raise the statute of limitations in this case.
But at that point in time, they were challenging the motion or the judgment, the summary judgment for judicial foreclosure. Once this court finally determined, or the Supreme Court and then this court finally determined that judgment was proper, they don't have any standing to go back and try to relitigate that again, even though they might claim some interest in the property at that point. There is no viable way that they can go back and then try to relitigate a judgment that has been entered against them on the judicial foreclosure claim and fully affirmed on appeal. Now, I also wanted to address the denial of the motion to intervene. Summary judgment was also entered, or a default judgment, excuse me, was also entered against the trustee of the Miller bankruptcy estate, through which the new Battle Mountain Corporation now claims its interest in this property, also in 1998. That default judgment was never, there was never any motion to set that aside or to appeal it, and it's the law of the case in this case. Now, the trial court properly denied the motion to intervene because as a matter of law, BMC 1996, which I guess is the nomenclature we're using to distinguish that from the original Battle Mountain Corporation, had no interest in the property. The trustee in the Miller bankruptcy estate submitted or filed a waiver release covenant not to sue and disclaimer of interest in September of 1998 in this case. And if you go to page 2 of that, the disclaimer specifically states that it will operate as a disclaimer under Rule 105. As a result, Battle Mountain 1996, it's jurisdictionally barred under Rule 105 F3 from coming back and claiming any interest in the property. And there's also a Supreme Court decision, Ford versus Summertree Lane, 56P3rd, or excuse me, not that, Vale Arrowhead Inc. versus District Court 954P2nd 608, that specifically holds that a disclaimer filed in a case is a jurisdictional bar to coming back and claiming any interest in the property. And as a result of the Miller bankruptcy trustee's disclaimer, couldn't come back and say, well, look, we now have some type of interest in this property, even though we disclaimed it over 16, 17 years ago at the time the motion to intervene was filed.
Counsel, files in this case are voluminous, so I may have missed it, but this sounds like something new that you're arguing now, the 105F3.
Oh, I don't think so. We had previously argued that the disclaimer, and that was cited prominently in our brief, we had previously cited the disclaimer and that it precluded Battle Mountain Corporation LLC from coming back in.
Yes, I understand that but I thought the argument at that time, or maybe still is, by virtue of the disclaimer, there just simply wasn't an interest to convey. And now I understand you're saying something a little different, that there's a rule that says because of this disclaimer, they can't come back, no matter if there was a valid conveyance or not, I presume.
Well, to the extent, I believe that the disclaimer the disclaimer was clearly cited and relied upon extensively in our brief. And I did not cite we did not cite Rule 105 F3 in the brief, nor the case I just cited. But as a matter of law, I think there would be a jurisdictional bar to coming back in and now claiming an interest in the property. And based upon that, there would be no interest in the property, and the trial court was correct in denying the motion to intervene. Lastly, to the extent that Battle Mountain Corporation asserts that the trustee acted improperly in signing and filing the disclaimer, I believe that would be some type of personal claim that the trustee in bankruptcy or that Mr. Miller might have against the trustee in the bankruptcy court, but would not be something that would be transferred pursuant to the personal representative's deed that they're relying upon now. And the site there is the Ford versus Summertree Lane case, 56 P. 3rd, 1206. The personal claims are...
Counsel, your time is up.
Thank you.
So the Court of Appeals case that addressed the Pine Martin PMMC parcel was 17CA0114 combined with 17CA2158. Those gave rise to standing for Sensible at the time of the final judgment. The trial court and the plaintiff have said over and over again, and yet here again, that the 1999 order fully affirmed everything, that Sensible had no interest, Battle Mountain Limited Liability had no interest, nothing was left after the 1999 order. And yet, the lender filed two separate motions for summary judgment, asking for foreclosure and asking to dismiss the counterclaims and the cross-claims. Clearly, everybody understood that there were claims left. And
Well, I think to be accurate, they're saying there was a sliver left as to Sensible.
Correct.
And then the summary judgment was on the foreclosure claim, and yet we have counterclaims and cross-claims for quiet title and the like. So those were to be resolved.
There's two parts. There's the foreclosure action, and then there's the counterclaim for quiet title. The lender filed a renewed motion for summary judgment on the foreclosure action in 2000 and in 2008. And then, because of the briefing, and it was incredibly convoluted, that didn't actually get decided until the final order that was entered. So the question is, you know, if the 1999 order really resolved everything, why are they still filing motions for summary judgment? It just doesn't make sense. And when you look at Battle Mountain 1, Battle Mountain 2, Battle Mountain 3, Battle Mountain 3, the series there is not perfectly clear. Battle Mountain 1 threw out the summary judgment that had been entered in favor of the lender and against the counterclaims. That order, the 1999 order, basically said, Mr. Tucker never became the owner, therefore nobody else has any property interests. The only thing that got affirmed through Battle Mountain 2 and Battle Mountain 3, aside from the statute of limitations issue, was that Mr. Tucker did not become the owner of the stock of Battle Mountain Corporation by virtue of the Nevis transaction. The other parts of Battle Mountain 1 were never addressed. They were never discussed again after Battle Mountain 1 threw those out. So the parts of the 1999 order, and I know this is incredibly convoluted, the parts of the 1999 order that were thrown out in Battle Mountain 1 remained thrown out, and that included entry of summary judgment against Battle Mountain Limited Liability Company and Sensible.
All right, counsel, you're out of time.
Thank you.
Thank
I
you.
appreciate it.
I want to thank the attorneys for your arguments today. The case will stand submitted. We'll issue an opinion in due course. We'll go ahead and allow counsel to set up for the second argument. Introduced the docket earlier. Do you have any questions about our procedures?
No, Your Honor.
Okay, then we're ready to proceed.
Good afternoon. May it please the court. My name is Peter Lichtman. My registration number is 50475. I'm here today representing the appellants Jim Reid, R.C. Smith, and Jerry Cordova. The appellants today are asking that this court reverse the decision of the district court denying the motion to dismiss that the appellants filed, and to take the record on appeal under consideration and to dismiss all claims against the appellants. We're asking this for two reasons. The first being that the district court erred when it found that the appellee had stated sufficient facts, specific facts, to demonstrate that there was willful and wanton conduct against the appellee, and that conduct rose to the level that it waived the governmental immunity that the appellants had. The second issue that we're going to ask you to address is the fact that the district court erred by not addressing at all the second claim for relief in the appellee's argument, in the complaint rather, that the court did not address whether or not that claim was even sounded in tort, and if it did, whether it was subject to dismissal pursuant to the CGIA. So with that in mind, let me start by saying, of course, the review today is de novo. The underlying facts of the case that were asserted in the complaint were accepted as true for purposes of the underlying motion to dismiss, and of course, for today's appeal are accepted as true. So there's not a dispute with that regard. Additionally, by way of background, I know the court is familiar that appellee had filed two claims against the appellants, alleging, among other things, wrongful termination based on Colorado's public policy law, and then intentional interference with contractual rights. What the appellants did at that point was file a motion to dismiss, alleging that the appellee had failed to state sufficient facts, specific facts, to demonstrate that the appellants acted in a willful and wanton manner to waive, essentially, their protections. The district court ruled that as to the first count, that the appellee had established willful and wanton behavior by virtue of the fact that she claimed there was a conspiracy. the district court did not address the second claim at all. So that's one of the reasons we're here today. So that's a bit of the procedural history as far as that goes. So to go to my first issue, whether the district court rather, erred when it found that the appellee had stated sufficient facts, specific facts, to demonstrate that the appellants had acted in a willful and wanton manner. And we don't believe that the complaint contains those specific facts as required. The Colorado Governmental Immunity Act does require, if you're going to be alleging willful and wanton behavior, that you state with specificity that those particular allegations. And then there's case law that interprets that as well. The Gray case that's referenced in our brief very clearly says that you must assert more than mere allegations to demonstrate willful and wanton behavior.
Counsel, I think what those cases are saying is that you simply can't allege that the behavior was willful and wanton. You have to allege some underlying facts. There are some underlying facts alleged here. I mean, and those facts are these defendants work together, they're protecting one of their own, and so they conspired to terminate the plaintiff. How much more specific were they supposed to get?
Well, I agree with Your Honor that there are those minimal facts, but I think those are more conclusions. There's nothing to indicate other than when the appellee says that they were friends, for example, that they somehow conspired. She's got no facts to rely upon to demonstrate that conspiracy. The fact that they were friends, in and of itself, shouldn't be enough to make a reasonable inference that they engaged in some willful and wanton behavior. I do think you have some of those factual allegations, but I think they're more conclusory. I don't think they're substantiated. What I'd like to see.
Well, counsel, it seems to me what you're trying to argue without saying so is that under the Warren plausibility standard now, essentially all cases are subject to Rule 9 of the civil rules that require, for instance, fraud claims to be pled with specificity. I don't think that's the law. You don't have to spell out time, place, exactly what was said, all of those things, but it seems like that's the crux of your argument. You've got to spell out those things or it can't satisfy the plausibility standard.
Well, and we're not arguing so much, Your Honor, the plausibility aspect. What we are trying to argue is that there needed to be specific aspects that needed to be addressed. For example, one of the important factors would be that the appellee established some right that was affected here. But when she talks about the grant, for example, she doesn't establish what provision under the grant funding, for example, she was reporting as being violated. She doesn't specify what grant it is, how she knows that this grant provision requires that Appellant Cordova couldn't work in Manitou Springs, which is in El Paso County 2 days a week.
But that sounds sort of like a factual dispute. What she says in her complaint, in essence, is, I got hired, somebody else got hired. Our job was to work full-time on money coming in from the federal government for a grant program. I worked full-time, my coworker did not work full-time. I know that because he didn't show up for work. When I told somebody about it, they fired me. That's retaliatory. You're not allowed to fire somebody for being a whistleblower, for exposing fraud on the federal government. You say, district court, you should accept all of those allegations as true. And now you say the district court erred because the district court found from those allegations that there was a wrongful termination in violation of public policy. And I'm trying to figure out if you agree with all of those allegations. You say those are all true, we should accept them as true. What exactly you think the district court did wrong here?
We're saying that those facts, as stated, as taken as true, are still insufficient to delineate that. I don't think it's reasonable for the court to have made an inference that there was a conspiracy based on those facts.
Well, there was an allegation of a conspiracy. That's a factual allegation. That would be a question of fact for a jury, not a question of law. I mean, you seem to be saying they had to plead evidentiary facts.
I believe that what they needed to plead was a clear delineation of how that conspiracy came about, what the elements of a conspiracy were. I also think that regardless of that, even if you were to somehow link this policy to a right that was somehow violated, my argument would be that the appellee then needs to explain how the appellants had this conscious knowledge that they were acting in this way, that they were disregarding some right that she had. If the appellants didn't believe that they were doing anything illegal, and if there was nothing alleged that they had knowledge that they were doing something illegal, how is it they could have that conscious disregard?
Well, she says I thought she said in her complaint that after she discovered what she calls wage theft, I'll just refer to as fraud, that she then reports that to various people at the county, and that the defendants, because they had an interest in keeping their own jobs and in protecting themselves, decided that they would retaliate against her. So there is I thought there was an allegation in there that they did have knowledge that she had exposed fraud, and that in order to protect their own self-interest, they were now going to try to get rid of her.
I think she did that, but she didn't provide any facts that indicated that they had that understanding, that they felt that there was any fraud that was being reported, as opposed to, for example, her just going and speaking to somebody in HR about her assumptions about what Appellant Cordova did, her assumptions about a grant that she doesn't specify exactly what the requirements of that grant are. She doesn't discuss whether or not she ever spoke to anybody to say, should Mr. Cordova be doing this? There's no indication whatsoever. So some additional facts would have assisted in making that clearer. So that's as to the first.
It
Yes, Your
sounds
Honor.
like you're saying she had to plead facts showing their subjective states of mind. But state of mind is something that can be inferred and is rarely proved by direct evidence. And again, you were willing to accept all the pleaded factual allegations as true and still are. And it seems to me the inferences that can be drawn from those comes along with that.
And if that is the case, Your Honor, our position would be that she needed to provide additional facts to support that inference. As to the second issue before us, the fact is that the district court did not even review the second claim. Now, the second claim, our initial pleading included the fact that we wanted the court to address whether this claim sounded in tort. That has since been conceded by the appellee, that indeed it's a tort claim. When you look at that claim, that 3-paragraph section of the complaint, it just states some conclusory allegations. It doesn't, again, address any facts. It doesn't address the elements of intentional interference with contractual rights. It doesn't address those specifics, and then it doesn't even go into how the defendants acted in a willful and wanton manner to violate her contractual rights. And I think she needs specification to link that up. Regardless, the court didn't even address that aspect of our motion.
Well,
And
counsel, the court has a separate section of its order entitled 12B5, and the only claim you sought to dismiss under 12B5 was the second claim. So isn't that addressing the second claim?
But it's not addressing it as to the 12B1 aspect, Your Honor. So we feel that the judge should have addressed it as to the sufficiency and whether he had subject matter jurisdiction to hear the claim.
But doesn't, I mean, if the facts are sufficient to show a conspiracy to fire the plaintiff in retaliation for whistleblowing, that would seem to be a tortious act, which would support a tortious interference with contract claim.
Then my argument, Your Honor, would be specify the elements of that claim and how it is that it's been violated, instead of just alleging it's been violated. I think that the pleading requirements require more specificity. I think that under the CGIA, it requires specific facts to be alleged.
Do you have any authority for that proposition, that there's a heightened pleading standard under the CGIA?
I don't believe it's heightened, Your Honor. I would look to the language of the CGIA itself, which says that if you're alleging willful and wanton behavior, you must allege with specificity those fact allegations. And then I look to the Gray case that's cited in our brief that also talks about mere assertions will not rise to the level to meet those allegation requirements. If there are no further questions from the panel, we are asking that the court reverse the district court. At a minimum, we're asking as well that as to the second claim, that the court engage in its reviewability review the record on appeal and make a determination as to the validity of that claim and to dismiss that claim as well. If I'd like to reserve the remaining time of my rebuttal.
Thank you,
Thank you.
counsel.
May it please the court, Robert Lichty, 14652. And I ask a favor of whoever writes the brief, if you could put language like this in, I'm sorry, the opinion, put language like this into the opinion, because I get this problem all the time. When you explain, please explain that employment contracts are almost always oral. Very rarely does a regular person have a written contract. That's reserved for CEOs. And they're almost always at will. But they are always a contract. And you can't believe how often I get that question. It's an oral contract, it's not a contract. If you could please just put a reference in that so we can have a case to refer to. It's at least a contract that is enforceable under the Colorado's Wage Claim Act.
Well, I thought there already was a case for that proposition, which you cited in your briefing.
I don't have a good enough one because I keep on getting, there's a case that you can interfere with an at-will contract. Yeah, there's 3 or 4 of
Right,
those.
okay.
I cited 2 of them. But if just that general statement, I think would really help us in the employment bar. In explaining some of the, I even had a judge once ask me that question. This was years ago, but it's still a question. That a contract, some people think a contract has to be something in writing. Well, it doesn't. The first claim, the wrongful discharge in violation of Colorado's public policy, I was looking that over this last week, and I think, and I was researching it, it only applies against the employer. So that would only apply against possibly Mr. Reid, because he was the decision maker in this case. However, that issue is not before the court. I'm just advising the issue that when we go back down, I think that issue is moot as to the other 2 defendants. However, the intentional interference with contract claim is basically the same claim. It's based upon the exact same facts. And it's based upon improper contract and trying to interfere, improper conduct in interfering with somebody else's contract, which is the same thing as wrongful discharge and violation of the Colorado's public policy in this case. It's a very, very similar question.
So I'm sorry, I just want to make sure I understand. Are you conceding
Yes.
that the non-decision makers, and that would be
Yes.
Cordova and, who's the third person?
Carter Smith.
Smith?
Yeah.
That they should be out of the case?
Well, no, just out of the first claim.
Okay.
The
But
first claim doesn't
second claim
apply.
is the same as
The first claim doesn't
claim.
apply to them, is what I'm saying.
Okay.
Only the second claim does,
Okay.
okay?
But if the second claim is essentially the same as the first claim,
Well, it's based upon the same facts.
okay?
It's based upon many of the same considerations that, when a jury looks at it, it's going to say, yeah, if there's one, there's the other. But the first claim can only apply against the actual employer, not third parties that are interfering with the employment contract. Second point I want to raise, yesterday afternoon, I found out that Dennis was reversed. I don't know if you've discovered that yet. 2 months ago, the Supreme Court reversed Dennis. Doesn't affect our argument in this case. It was reversed in 418 P3rd 489. It was a 4-3 decision, which I think is kind of rare with the Supreme Court. Normally, they're more unanimous, but it was a 4-3 decision. Judge Reid, Chief Judge
Rice.
Rice, yeah, she was the one who wrote it. But we relied on page 19 in our brief. We relied upon paragraph 25 from the Court of Appeals opinion, which was also relied upon by Justice Rice. And that is, the immunity inquiry is for the court. And here are the words that I put on page 19 that really bother me in trying to get a feel for what this means. The immunity inquiry is for the court to satisfy itself of its power to hear the case. The Supreme Court said this, and this is on page 494 of the Supreme Court's opinion. Because tort concepts are naturally subjective, the district court should not fully resolve the issue of whether, and she underlined whether, the government has committed negligence. As you call in Dennis, that was the unreasonably dangerous condition in a road, and then the liability question would be, was the city negligent in failing to fix the dangerous condition? In our case, it's whether the employees have intentionally interfered with plaintiff's contract. So that's not what the court should resolve. Rather, the court should only satisfy itself that it has the ability to hear the case. What does this mean? To have the ability to hear the case. It was key in both of the cases, both the Court of Appeals and the Supreme Court. Is this similar to a preliminary injunction standard where the plaintiff would have to show a reasonable probability of success on the merits? You can go to McLeod 612p2nd 1158 for that. Compare the Martinez case, which we cited in our brief. That's the Supreme Court case concerning the police officer who was trying to take into custody a person who had some mental problems. And the officer went to restrain him. Officer still had the gun in his hand and shot the arrestee. Whether that rose to the question of willful and wanton was the question on appeal in Martinez. And the Court of Appeals said that's probably enough, and the Supreme Court said no, that it had to go back down to the Court of Appeals, back down to the district court, because the district court's judge did not properly apply the correct willful and wanton standard.
Yeah, so can I ask you about that? Because
Yes.
what Martinez stands for is the proposition that it's not enough for the trial court to say you sufficiently pled willful
Yes.
and wanton.
That's
You
correct.
actually have to establish willful and
That's
wanton. And the
correct.
trial court actually, because it does have a duty to make sure it can hear the case, has to determine in factual
Yes.
findings that the conduct was willful and wanton.
Right.
So here, the district
Well-
court didn't exactly get that far.
Let me cut to the quick on that one.
Okay, great.
The defendant has the right to strategize how they want to do their case. If they want to save on some costs or go with a full hearing or whatever. So the defendant claiming immunity can say, I'm going to go on the pleadings. There are no other facts in this case. We don't even know what facts the defendants are going to admit or deny. There's been no answer. We don't have anything. In Martinez, there was already a fully developed record. There was a summary judgment record in the federal court. Then it was dismissed. The federal court didn't exercise jurisdiction over the state claim. That came down to the state court. So you had all the facts already developed. And at that point, the district court, what the Supreme Court said was the district court, given the record in front of it, it had to make a finding on whether this conduct rose to willful and wanton conduct. Now, how does that square with the other language of determining whether the court should only satisfy itself with its ability to hear the case?
Go on.
I think it's an incredibly difficult question. And I don't think we have an answer. And I think that's one question that this court is going to have to try to reach. Now,
Well, can-
it's easy in this case. I don't mean to interrupt. I'm cutting
No, go
myself.
ahead, go ahead.
It's easy in this case because you only have the pled facts. That's all you have. So this case really has to follow the precedents of Gray, where given these facts, and we're going to assume they're true, as you have to, hasn't been challenged yet in a Trinity hearing. So this case is really a fairly simple case in terms of how this court can handle the precise facts of this case. It just falls right underneath Gray.
Okay, so then just to, I'm sorry.
No, go
Judge,
ahead.
go ahead. No, it's your turn.
But my challenge to you is, what do you do with that other language? That's my challenge to you.
So I'm perhaps struggling with what Judge Harris is struggling with. So if the court needs to make its own findings and it determines that, it either determines that it doesn't have sufficient information to do that, just referencing the pleadings, is there some obligation then on the court to further develop the record in order to rule and make the necessary findings that it needs to make?
Yeah, I didn't understand the case before, but I think that was hidden in there, if I'm reading between the lines. No, the court is not a coach. The court is a referee.
No, but the court
The
has to
The court
figure
doesn't tell the
out,
parties, okay, you have to
but
have a
the court
hearing.
has to figure out whether it has authority to hear the case or
Yeah.
not.
And it can, if it just wants to be on the pleadings, okay, I'll decide on the pleadings. If you want to ask for a hearing, in this case, a Trinity hearing, special for this type of case, I'll go ahead and have a Trinity hearing.
So if the court here, under Martinez, needed to make additional findings, which it either did not make or could not make based upon the complaint alone, the pleadings alone at this point.
I disagree with your language, could not make. It can make it based upon the complaint alone.
Okay,
Because
well-
this, again, is a motion to dismiss, the rule's clear, I have to take the well-pled facts as true.
All right,
So
well,
it
let's
can
not
do that.
argue the could not. If it did not make necessary findings, what is it you are suggesting is necessary then at this point for the court?
Oh, at this point, I think this case is really simple. This particular case, handling just the facts here, just affirm and send it back. Now, then we have our attorney's fee issue. I'm not going to talk about that. If it's clear, it's clear. If it's not, we don't get the fees. But this case is really simple. I'm simply raising these issues in the event this court sees this case as a good opportunity to advance and clarify the law, or you don't have to. The ball is in your court, but you don't have to play this one.
Can I throw another
Sure.
factor in here? So what about, there's a statement in Finney, and in that case, the Supreme Court says, courts have discretion to conduct Trinity hearings to develop facts relating to immunity issues when such facts are not directly disputed. So that sort of goes back to Judge Ashby's question, which is, well, is there some sort of independent duty on the district court to make sure that it has jurisdiction to hear the case, even if the county is saying, oh, no, we're going to persist in not challenging the factual allegations? Does the district court have some obligation?
That's what I was wrestling with last night, and that's where I came up with the idea. I remember when I was, years ago, a federal judge said, no, we're not. We're just referees. We don't manage the case for the other party.
But jurisdiction is different because.
But in this case, the jurisdiction is established by the complaint. Then the defendant can say, okay, I'm just going to rest upon the facts in the complaint. We know what those facts are. They're clear. There's no dispute. It's clear as to what those facts are. Or I can challenge those facts. Now, say we had written a really bad complaint. It was just all conclusory allegations. Well, smart defendants could say, I'll save some money here. I'm just going to challenge it on the complaint. Boom, it's out. And we lost. In this case, I think the facts are well enough established to get by the immunity bar. Now, the next question is, okay, when we go back down, and I don't know if you want to give guidance to the court in this case or not. You don't have to. But if you do want to give guidance to the district court, what does the district court do in what I anticipate to be a Trinity hearing? Is the Trinity hearing basically a trial? Shouldn't be.
Counsel, I want to get back, though, to what I think is really the issue in this case.
Okay.
Okay, instead of talking about other cases.
Okay.
And that is, it seems to me it really comes down to what this statute 24-10-110 subsection 5 means. That statute says that in any action which allegations are made that an act or omission of a public employee was willful and wanton, the specific factual basis of such allegation shall be stated in the complaint. The next subsection goes on to say that if you don't do that, the complaint shall be dismissed.
Right.
So that seems to be a heightened pleading requirement for willful and wanton conduct. And why have you met it here?
No, it's not heightened. You just have to plead facts that show willful and wanton conduct.
Yeah, well, it says specific factual basis. It doesn't say a factual basis.
Yeah.
So
And-
it's
and-
kind of like Rule 9B under the civil rules for fraud. Got to be pled with specificity.
And we did plead with a certain amount of specificity. We can't get any more because we don't know. All she knows is this. She knows the two of us are supposed to be working on this project. He's not working on the project with me. I complain. Smith and Cordova are friends. They've moved into each other's office. They're friends with Reid. They've convinced Reid to fire me. They get Reid to say that I'm no good. I didn't do my job. And she knows from four other people that, you did a great job. So it's a pretext, which is, typical employment burden of proof. But I believe that the facts are, they're clear. And it certainly is not a leap of faith to believe that those facts would show that there's willful and wanton conduct. I see my time's up if there's any other questions, but,
Thank you, counsel.
okay, thank you.
Thank you, Your Honors. Your Honors, to kind of dovetail upon what was discussed, as was discussed referring to the Martinez case and the Gray case, and then the 24-10-110 subsection 5, that specifically does require specific facts be pled, not just mere assertions. So that goes back to our statement that we don't feel that there were specific facts pled to meet that burden. And then in addition, in light of what counsel just informed us, it seems automatic that now R.C. Smith as well as Mr. Cordova be dismissed from both claims. Certainly, claim one, as they've just conceded, but the facts in terms of any type of willful and wanton act would certainly be the same type of facts that would be applied to them in the second claim. So I'm not sure how they could not be dismissed out of that. Regardless, we'd seek that the overall decision of the district court to deny our motion to dismiss be reversed, based on the fact that we needed more specific factual findings.
I've got a question that, it does go back to, well, what happens in this case going forward if we do one of two things? If we reverse, okay, that's pretty clear. But if we affirm, then does the city then come in and can it request a Trinity hearing, or has that ship sailed? You had your shot and you're done.
I can tell you, I don't think that the county would actually proceed with the Trinity hearing. I think if the court affirmed and we went forward, we'd start engaging in the discovery process, we'd go through that. The need for a Trinity hearing to determine whether the next step would occur, typically it's not something we would do. We think that right now, the way the allegations are, that's what they're working with. It's up to the court, I imagine, if the court wants additional information to determine whether it has subject matter jurisdiction.
So just to clarify, if we were to say, well, we think the district court actually needed to make findings, not just say that the allegations were sufficient, if we returned it to the district court, you would persist then, you're saying in the district court, you would say, well, we don't need any Trinity hearing, we want you to accept the allegations as true.
Well, no, if that were how this court made that determination, I think we would then, it would be appropriate because we'd need additional factual findings, so perhaps we would ask for a Trinity hearing.
Okay.
Okay, I believe my time's up. Are there no further questions? All right, thank you.
Thank you, counsel. Thank you, counsel, for your arguments today. Case has been submitted. We'll issue an opinion in due course. Have counsel checked in for the 2:30 argument? I'll tell you what, we'll take a recess so that we can sort all that out. So the court will be in recess and the bailiff may so announce. instructions, I assume you weren't, the only things I want to reiterate are that we should turn off all of our cell phones. And secondly, that the podium is adjustable in terms of whether it goes up and down. So keep that in mind. If you have any other questions, I'll answer those. Nope. So we'll proceed. Counsel?
Thank you, Your Honors. Good afternoon. My name is Kim Engelhardt. My registration number is 44513, and I represent a mother in a dependency and neglect case who appeals the termination of her parental rights. May it please the court. I want to start with a direct quote from the caseworker from the hearing held on April 20th of 2017, where he stated that if they truly are the responsible adults that should have a child returned to them, they will take care of those things themselves. Those are the caseworker's words from a termination hearing that was held in April of 2017, where the court did deny the motion to terminate as far as mother. Even at that time, however, the caseworker supported termination, and it appears that he supported termination of mother's rights as early as November of 2016. Caseworkers are tasked with working with parents who are struggling, whether it's with indigency or substance abuse, mental health issues, maybe they're trapped in a cycle of domestic violence, maybe they're struggling to find housing, and they're also required to make reasonable efforts to reunify these children with their families. And given all the issues that these parents may face, that's not an easy job, but the efforts must be made.
Counsel, may I ask you a question? I think I understand where you're going in terms of whether there were reasonable efforts made to assist mother with housing.
Yes.
Even if we assume that the caseworker's statements or testimony may have suggested that a standard that we might think was generally not sufficient. In this particular case, as I recall, they had found a place for mother to go, the shelter. So they had effectively found housing for her, but she chose not to go to that housing. How does that affect your argument regarding reasonable efforts?
Well, part of the issue there is that the facility that they identified would separate mother from father, but it also would create some geographic distance between mother and the child. So she was essentially in a difficult position as far as choosing which route to take. And in addition to that, the housing that they identified was specifically intended as a protection against domestic violence, while mother was actually living with family locally, specifically her great-grandparents.
Right, but wasn't there a concern as to whether that particular housing would be appropriate more long-term for mother if she were seeking to have the child returned to her because of their lack of cooperation and willingness to engage with the department or allow the department, for instance, to visit, those kinds of things?
I know there was concern about their unwillingness to cooperate with the department or to have them in the home. However, there were no safety concerns that were identified in the first place, and so essentially they were requiring these great-grandparents to prove that there were no safety concerns when none had been identified as to them. Specifically, one concern, even mother, I believe it was testimony where she indicated that the whole family does use marijuana, but there was no evidence to show any kind of imminent harm that would be caused to a child. There was no indication as to frequency of use or the amount of use. So essentially, the department took these family members, who could also be presumed to be fit, and put upon them the requirement that they prove the safety of their environment. And because they didn't want to cooperate with the department, they never were able to show that it was a safe home, while there was no showing that it wasn't a safe home at the same time.
But if the child was going to be residing in that home, with mother, and the department needed to continue to monitor mother's parenting of the child while the two of them would perhaps be living in the home, they would need access to the home to do that, right?
Not necessarily. There are all sorts of indicators outside of going into a home that can show whether the child is safe or not. Medical examinations, drug testing, mental health treatment and evaluations for the child that are ongoing. In particular, the testimony, and it is highly emphasized in the opening brief, the testimony that was provided by the caseworker in April of 2017, because mother believes that it's very telling as to the type of working relationship that she had with the department and the caseworker, and I believe that the family may have shared that sentiment with respect to Department of Human Services caseworkers. So I think that was a big struggle that they were unable to overcome.
Well, Ms. Engelhardt, what were the efforts that you think the department should have made with respect to the housing piece of it? Let's start there.
I've certainly worked on cases where a department would match funding for fixing a roof. They do help with rent. They can also recommend other resources. I know they can be limited, but the department does have funding. And
But
they,
like, for example, in this case, the helping with rent, I mean, if mom had identified a place she could live and then had asked the department to help with rent for that place, and the department had said, no, you know, you have to do it on your own, like whatever the guy said at the hearing, okay, that would be one thing, but it didn't seem like that's what happened here. Mom said, I'm good at grandma's, and that was about it.
right, and I understand the court's concern with that. However, if someone is a victim of domestic violence, they may feel more comfortable living with family, and that was part of the concern too, is the lack of sensitivity toward mother's issues, and the inability to recognize that she may have been in the safe place that she needed to be.
Well, that's
I-
confusing to me, because you just said she didn't want to go to the domestic violence shelter because she wanted to stay with her abuser, and she wouldn't be able to stay with the abuser if she went to the shelter.
No, she would have had geographic distance between her and the child at that point. I apologize if I was confusing about that. And I do think that there is a lack in the record of mother actually raising the issue of, I have a house, may I please have a deposit, or something of that nature. The court is correct that she did not make that request. I don't believe that specific request is preserved in the record.
So in the context of this case, is there anything that you think the department, I mean, sort of specifically given these facts, that the department should have done that it didn't do?
Well, under the circumstances, it's essentially mother's position that they created a housing problem for her by rejecting these family members because of their unwillingness to cooperate with the department. So under those circumstances, reasonable efforts, I think mother asserts, would be sitting down with her, looking at possible options and what kind of funding might they have, how can they help her with these things. And no efforts were made. That was part of the problem, according to the testimony, that no efforts were made to help mother find housing, even though they rejected the place where she was living at the time.
Counsel, if I'm understanding the record correctly, at the house where she was living with her grandparents, there was also an uncle and his children?
Yes.
Okay, so we got a crowded house situation. We have mother saying everybody in the family smokes weed. I think that's how she put it. And we've got the owners of the house who won't let the department in. I mean, that sounds like a lot of red flags.
Well, we don't know that the house was crowded.
Well,
It's
could have been a huge house, I guess. Yeah,
It
true,
could have,
true,
and
yeah.
it's not clear.
Yeah,
And again, as, you know, if we're talking about breaking up a family or removing children from their parents and removing children from their uncle, their great-grandparents, all of these figures in their life, yes, mother did give significant reasons for the department to intervene. And then at that point, she needs to be rehabilitated, comply with the treatment plan.
but the department has to look out for the best interests of the child, okay, not mother, the child.
Correct.
And so when they're told, you can't check out this home that we want the child living in, what are they supposed to do? I mean, it seems to me they have no other choice but to say no to that option. Because they have to assure themselves that this is going to be a safe environment, and the owner won't let them do that.
Well, they do have things such as safety plans that they can develop. Again, you can make observations of the child outside of the home. And I know that the prevailing interest is the best interest of the child. Safety is obviously a huge concern there, but another interest to be weighed is certainly preserving the family unit. And if they're not permitted to be in the home, I do think that there are other ways that the child could be observed and that they could make sure that the child is being, kept safe. And again, they have sort of some unknowns about the great-grandparents and the uncle. Is the house crowded? Are they using marijuana in a manner that would be harmful to the child or prevent mother's ability to safely care for the child or put the child in an unsafe environment? These are legitimate questions, but at the same time, if essentially, these people haven't done anything wrong. And so if the department has a question about an unknown, they shouldn't speculate and say, well, the child's obviously not going to be safe. It's simply just not putting enough deference on the family unit and the importance of preserving that.
What about the fact that it seemed that the district court actually didn't put that much emphasis on the housing problem? Seemed like for the district court, its main concern was really that mom had decided she just was not going to stop using drugs, including methamphetamine, and that she also might have had some mental health problems. And the court really was focused on the fact that mom could not take care of the child. It didn't really matter where mom was living. She was not going to be able to take care of the child.
Well, and if we look at the first 6 months of the case, mother was doing really well. And the caseworker was, or the department was considering moving to less restrictive visits and things of that nature. I do think that relapse is a significant concern. And it's always a possibility, and it's usually an inevitable part of obtaining sobriety. So that's an issue that the department needs to be sensitive to, and I do recognize that there are time guidelines by which a child must achieve permanency, and particularly in EPP expedited cases where the child is under 6. But at the same time, in order to make reasonable efforts, the department does need to recognize that it might take a little bit longer to rehabilitate a parent. So if we can achieve permanency and keep the family together and also allow these parents, enough time to become sober and stay sober, we're really serving the best interests of the child all around.
So that sounds a little bit like an argument that maybe the department didn't recognize that mom could have become fit within a reasonable period of time.
That's correct. And that also goes to reasonable efforts, allowing these parents enough time to become rehabilitated. And ultimately, at the time of the September 2017 termination hearing, mother knew that the department intended to terminate her rights since November of 2016. So during that time, and she also believes she was set up to fail. In particular, the testimony about the housing, she believes is telling as to the caseworker's attitude towards helping this family to stay together. And when parents believe that they're set up for failure, they often lose hope, and they do often fail. So the housing issue was, I think, very significant in mother's mind, and a lot of it goes toward the working relationship with the caseworker. So even if they write a report and say what efforts have been made or things that mothers has failed to do, that doesn't mean that the reasonable effort standard has been met. I understand the court's concerns as well, but the trajectory of the case can change when a parent has a relationship with a caseworker that goes south, and that's precisely what occurred here.
Was there a request to have the department consider a different worker working with mother?
There was not, to my knowledge. No. Another piece of testimony that mother found telling was at the termination hearing, she did actually testify that the child had begun referring to himself by a different last name. specifically the foster care provider's name, I believe. And that was a huge concern as well. Termination hadn't been ordered, and the adoption hadn't taken place, and the child was still referring to themselves as a different last name. So the attitude of the case changed fairly early on, before September. And at that point, mother believes that the reasonable efforts stopped, and some of them were not made even prior to that. We have a caseworker who was supportive of termination of parental rights almost a year before it was actually granted. So in that time, progress was not made. And we have parents with a lack of resources, with substance abuse issues. Methamphetamine is incredibly addictive, and the department has the resources. The department identifies the problem, and they need to make efforts as best they can to not only ensure the safety of the children, but also to keep the families together. I have about 5 seconds, so I don't think I'll have time for rebuttal, but thank you very much.
Thank you, counsel.
Good afternoon. My name is Jim Ripperger, registration number 6169, and I represent the Huerfano County Department of Social Services. By agreement of all counsel in their briefs, we've felt that the standard for review was clear error, because the allegations in the appellant's brief are essentially that the court did not make correct findings of fact. Since the trial court is the ultimate arbiter as to the weight of the evidence and the credibility of the witnesses, my understanding is that this court simply is looking for whether or not the record substantiates or gives the court sufficient evidence in which to base its rulings. My entire brief, or at least 99% of it, I would say, is an effort to point to the court the various places in the record which deals with the very issues that counsel has suggested the court did not consider appropriately. The arguments mentioned by counsel before the court, a lot of them are based upon her assumption as to what happened, as to what actually did happen in the trial court. The indication that she was set up for fail, it seems to me from a different standpoint that the Department of Social Services, after having custody of this child for a year with no progress, had it brought the matter before the court for termination of parental rights in December of 2017, I believe it was, 16.
Well, can I just
Absolutely.
make a comment about that? Because it looked to me, and maybe you can tell me if this is accurate or not, that the treatment plan is adopted in mid-April of 2016, and by mid-June of 2016, the department has filed to terminate parental rights. That's
For
2 months.
The first time, Judge, but the parties would have known what they were to be addressing in the meantime. Mother entered a plea much earlier than we got to the father's default for adjudication.
She entered a plea in March.
And so
Then
she would,
there's a treatment plan in April, and then there's a motion to terminate her rights in June. That does seem pretty fast. You could imagine a person would think that they hadn't had much of a chance.
well, and again, in accordance with the case law, a filing of a motion for termination does not suspend the treatment plan. So given the fact that the parents have automatically under the statute have an additional 4 months to work on a treatment plan, the fact that we filed indicating the case was going off the tracks didn't mean the parent was suspended from visitation, from going to drug and alcohol treatment, from UAs, from any of the other things that they're trying to address. But my point simply, Judge, is that the parents would have known early on those issues that they needed to be addressed well in advance of the court's formal adoption of a treatment plan. And as counsel has already indicated, Mom was doing well the first few months. And even though we didn't have a formal adoption of the treatment plan, we were ready to begin monitored visitation until she fell off the rail by not only relapsing with the drugs, but doing it with the domestic violence partner in Denver. So it was of great concern, and so that was derailed as well, the plan to go to monitored visitation. Council has indicated that the Department of Social Services had approved the placement where the child would have been for monitoring, and that's not established by anything in the record. One of your members of the Court of Appeals had asked, and I totally agree with that, is the Department of Social Services would have had to monitor that child's placement wherever the mom would have been. We wouldn't have started, by the way, with placement. It would have been visitation, but it would have been in the home. And by the Department of Social Services recommendations, we have to check the background. As Judge Jones has already pointed out, Mom has said every member of the family smokes weed. That's where she's getting her free weed. And this home is full of adults as well as other children. I pointed out in my brief, and it's on the record, that this particular mother has not only, the grandmother has 3 daughters, all 3 of which are involved with the Department of Social Services, and all 3 of which have the same kinds of problems. The standard that the Department of Social Services would be looking for would be a turnaround, that there would be no more enabling of the problems that are causing the removal of all these children from this same family unit. So to assume that this was an appropriate home is going too far. We would have needed access to that home, which they were not willing to give. And of course, they didn't like the Department of Social Services for good reason. We had already involved ourselves with 3 members of that family and removed the children that were involved with them.
Counsel, would you agree that the statements or the testimony of the caseworker regarding perhaps his perception of if and how he was to help mother, specifically with respect to housing, suggested that perhaps there was more he could have been doing?
Judge, his comment was very glib at the time. That was the second time we tried to bring this matter to a hearing for termination of parental rights. We didn't just try, we actually did bring it. And I take the responsibility for the failed effort because we had such a record by that time of a full year of reviews, of failures to address the drug and alcohol or the drug issues, no UAs or failed UAs and so on. I relied upon the solitary testimony of the caseworker as well as asking the judge to take judicial notice of the several orders and reports that had already been submitted. Judge Appel rightly said, I don't think just the testimony of one caseworker is going to be sufficient here. He did not find by clear and convincing evidence. And I'm sure you've reviewed the record, we pushed back, we asked him to reconsider, and I cited him to all of this record, this history of the case, and he did not change his mind. But he essentially said, if Mom continues not to work, you're free to refile. And that was one of my original points, is that Mom has had essentially 3 bites at the apple. She knew in April of 2016 she'd gone off the rail. At that time, they alleged that there was a potential ICWA issue, and so she bought herself another bunch of time to April. By the time we got to April, there'd been no change, no addressing the treatment plan and that. We went through that hearing and we failed. So she then bought herself an additional amount of time. By the time we got to September, there's still no change. And it was during that period of time, as it was pointed out by the court, that 3 different service agencies, the caseworker, Nicole Dickinson, who works for the Family Services Center, and the therapist Ginger Watley had all pointed out there is a place you can go in Trinidad, which is a women's shelter, and not only that, that women's shelter will allow the child to join you. Now, that child would not have joined her in the women's shelter if she continued to have the drug problem. That had to be addressed no matter what. The issue of, it would separate me further from my child, the Department of Social Services provides transportation out of Walsenburg because of the few resources in that county and the heavy dependency and neglect docket, the Council of Governments provides a bus because we place a lot of children by necessity outside of the county. So Trinidad would not have been a major problem. That's pretty close considering where we have to place a lot of children. But the transportation is always provided for her. I'm afraid I don't want to go much further. I want to give the guardian ad litem as much opportunity unless the judges have any questions further than that. Thank you.
May it please the court, Anna Ulrich, 33367. This case involves a child, of course. We'll call him JV. He's actually going to be 5 years old in a couple days. He was removed from parents' care when he was 2 years old and placed into foster care at that time. He's remained in foster care since then. As stated, this is an expedited permanency planning case. At the termination hearing, almost 2 years, the second termination hearing, of course, almost 2 years had passed since the case had been open. And so we are talking about a case where we're well past the timeframes set out in the EPP statutes. I don't think there's really any legitimate basis that mother did not have sufficient time, particularly considering the fact that the department did, I would say, move aggressively for the initial termination, recognizing those EPP timeframes, because of course, once you file the motion, it doesn't get set until many months later. And I'm sure the department was thinking of that. I was not the trial court GAL, but I have no doubt that was part of the rationale. But the truth is the department lost that motion, as Mr. Rippiger has pointed out. And there was essentially an additional year where mother had the opportunity to take advantage of the numerous services provided for you. I know mother at this point in time argues that the department did not do enough to secure her housing. But I'd like to pull us back to the statute that, or at least one statute we're dealing with here, the required services. There's certain services that departments are required to provide in these cases, and this is set forth in CRS 19-3-208, sub 2, sub B. And housing is not one of those listed. They do have to provide information about, public assistance and public programs, but they don't have to provide housing. And then even under the next subsection, it lists certain services that should be provided if funding is available, and housing is not under those either. And so while I don't necessarily, I wouldn't be happy to have been at the termination and heard how the caseworker responded to the question, because I don't think it was very sensitive to the nature of these types of cases. That being said, I'm not sure he was completely factually inaccurate. Housing is certainly one of those things we do like departments to assist families with for the reasons that council mentioned. We want to reunify families, and certainly housing is a big piece of that for a lot of these folks who are indigent, and we know that. But it's not one of the things that absolutely has to be required under the statute. And I would say mother was not necessarily homeless. I think the record is a little vague as to whether she actually wanted to leave her grandmother's home versus sort of being happy with the status quo. I did not see, overall, if you look at the record as a whole, there's not a lot of overt action by mother in general, and certainly regarding the housing piece. She knew she couldn't have her child there for the reasons that we've already discussed, that I think it was her grandparents would not cooperate and let the department in, and she wanted to have her child back, but she never sort of advocated, at least as I recall, for that next step. I need help with this. To the extent the providers in this case said, this is an issue. We can't, it looks like you can't be reunified with your child until, you find a different housing situation. The responses were lukewarm, and they, recommended the domestic violence shelter. I would also point out that there were other services that would have likely led to housing had she taken advantage of those. For example, the job readiness program, which would have assisted her in attaining employment, which presumably she could have used money from employment for housing. She did not participate in that despite the encouragement of the various professionals. And I would also note that the case started, the family was already in public housing, but they were evicted because they did not follow the Section 8 rules. And so they probably had burned their bridges with, the formal public housing program. Now, counsel for mother states or suggests that the relationship between mother and the caseworker was really probably a lot to blame for mother's lack of engagement, but I'd like to counter that because mother also had a therapist and a coordinator who, at least from a review of the record, she seemed to have a decent rapport with, but she failed to engage with these services as well. She'd go on, she'd stop attending, she'd go one more time, she'd miss several meetings, and then ultimately they would have to discharge her. So I don't think, regardless what the relationship between mother and the caseworker was, I don't think we can put the blame on that. And also, I would like to point out this fact of sitting down with mother to discuss housing. Mother would miss family engagement meetings. Those are meetings that are set to talk about what services mother's participating and what might help her if she needs more, what's available. That's the purpose of that whole program. She wouldn't go to these meetings.
Before you sit down, Ms. Ulrich,
Yes.
sorry, can I ask you a quick question
Sure.
about something that Mr. Ripperger mentioned? Is it the department's position that the time period before mother has entered an admission or been adjudicated, the kids have been adjudicated, dependent and neglected, that that time period can properly be used to determine compliance with a...
Well, just to clarify, I can't answer for the department. I think as far as EPP guidelines, yes, I do think you consider the case as a whole. A child should be in a permanent home within 12 months absent a showing of, best interests, and we often continue them to give parents additional time. I think treatment plan, a treatment plan is only effective once it's adopted. That's my position as the guardian ad litem. That being said, it's not the filing of the motion for termination that is sort of that endpoint. It would be the termination hearing.
Sure.
So,
But I'm talking more about the beginning point.
Mm-hmm.
And you're saying the clock really starts, especially in an EPP case, when the kid's taken out of the home.
yes, I think that's when you start the clock running on an EPP case, not when the treatment plan is. And that, I believe that would go back to the statutory language.
Okay, thank you.
Yep. Thank you.
Counsel. Thank you,
Yes.
counsel, for your,
Oh,
thank
sorry.
you. That's all right. Thank you, counsel, for your arguments today. Case will stand submitted. We'll issue an opinion in due course. This is the only case on our docket for this afternoon, and so the court will be in recess, and the bailiff may so announce.